Wonderful, and welcome everyone to what is my first webinar. The topic today will be what to do when things get tricky. Now, this is sort of a topic that's quite close to my heart. It's something that I deal with every day, and I know that unfortunately it's something that you have also dealt with at one point in time. Now, this topic considers essentially what to do when you have a tricky client under a contract for residential building works. Now, sometimes your clients can be difficult from the start, sometimes they can be difficult towards the end, sometimes they can be difficult the whole way through. What this presentation aims to do is to just give you a few tips as to how you can deal with these situations as soon as they arise, and essentially point you in the direction if you do need any further help, later on down the track. So as with all presentations that I present, I generally give a disclaimer, which this one here is in relation to disputes with clients under HIA contracts. Any advice that is given today will be general advice, but if you do find yourself in a situation where it has become a little bit tricky, a little bit nasty, you can seek specific advice from either myself or a solicitor. So the way that I generally start this presentation is, just a general run through of those things that, I've learnt during my time, not only with HIA, but as a practicing solicitor. So back in the day, I was once told that if you fail to plan, you essentially plan to fail. These words have been spoken by many, very wise people, and they're absolutely right. Unfortunately, there's been a lot of situations that I've come across that could have resulted in a better outcome for the member if they'd sort of taken the time to, first of all, try and work out what the issues are, possibly have come to see me so that we could have, I suppose, moved on to a better resolution for them. Now, we don't want to end up in court. I was always told as a law student, if you end up in court, you've failed your client. However, generally speaking, it has to get to a pretty bad situation for it to end up as a litigation matter. In all circumstances, though, prevention is better than cure. So if you can help yourself early on, it will help others, such as either myself or a solicitor, to help you. If you sort of tackle those issues sooner rather than later, they haven't escalated, and you're probably in a more clear mindset as to how you want to resolve them. So here's just a few tips as to my best advice, and these are just based on sort of the feedback that I do get from members, and the advice that I give out to them. So first and foremost is to have a contract in place. You'd actually be surprised at the amount of people that come to me that either don't have a contract or have a contract in place and they don't actually use the contract how it's intended. Knowing your contract and how to apply it is important. Now, the next dot point says have a process in place to deal with any issues that arise as they arise. Now, this is important. Like I said, if you deal with them sooner, it's just nipping it in the bud and getting it out of the way. Most of the time, if you sort of have clear communication with your client, you can generally work it out. If you leave it for too long, it's like a big snowball effect, and a little issue then turns into an issue bigger than Ben-Hur, and then it takes a lot of work to try and resolve it. Which then leads me on to my next point, which is making sure that you keep your lines of communication open with your client. Again, it's also surprising for me to see the amount of different matters that come across my desk where there has been a simple breakdown in communication. What I do encourage is for you to always, include your clients in discussions, to encourage them to have the discussions with you if they do have any concerns, but to also be in a position yourself to have the discussion with the client to clarify a situation in the event where they say don't understand it. We also need to keep in mind that we're all customer service providers. I provide a customer service to you as a workplace advisor here at HIA. You provide a customer service to your clients in terms of, you know, meeting and greeting, sitting down and going through your contracts, going through the building process, and then obviously the handover process. Irrespective of, you know, whatever industry we work in, customer service is vital. The next thing is, don't be afraid to ask for advice if you need it. Generally we see people sort of bury their heads in their sand, and they sort of don't deal with it because they don't want to ask for advice. I'm here as the workplace advisor. As Kerry mentioned, I've been here since May 2013, so I've been here for quite a while and I've dealt with a number of you. But we're here every day so that we can help you in the first instance. There's no such thing as a silly question. It's better to ask the question and get the answer that you expected than to say not answer the question and not have the answer. Now, my final point here is be prepared to defend yourself when necessary. Now, I don't want this to be taken out of context, but most people don't like confrontation. However, we also have people that don't like to sort of give in to clients where they might be taking the mickey out of them or something like that. A lot of people will fight things on a matter of principle, but we need to sort of ensure that we're doing what's right for you. If you're going to defend yourself, you have sort of the supporting documentation behind you, and you're in a position to defend yourself properly. Now, if it does come down to defending yourself, you might say contact me, or you might contact your solicitor, and you know, particularly when you sort of end up in a litigation matter and you're in court or before the tribunal, you know, you might also have legal representation there. So, you know, disputes, dealing with tricky people, they're all a part of business. We hope that, you know, you don't come across it all that often, but unfortunately we are living in the day and age where, you know, we have things like Backyard Blitz in the block and, you know, other reality TV shows which sort of give an unrealistic expectation to a client as to how quickly you can get things done, how perfect their bathroom is going to be, whether they're going to get 10 out of 10 from the judges, all of that sort of stuff. So we just need to make sure that, you know, we're looking at all of these different options. Now, what I've done for the purpose of this presentation is I've sort of just picked out a common issue that comes across my desk. Now, this one specifically in regards to a client that hasn't paid their last progress claim. Now, I would almost bet, you know, my $5 that I have sitting in my top drawer for my coffee, that you've all been in a position where a client has, you know, sort of questioned your last progress claim. Now, you want to know what you can do about it. So what I'm going to do is I'm going to ask a series of questions so that you get sort of an idea as to where the matter has come from in order to determine where the matter is going. And I'll discuss each of these questions in a little bit more detail in the next few slides. So if we look at what has happened, so the client has not paid their last progress claim, but, you know, they've contacted you either by phone, text or email and said that, you know, they'll pay you within a week. Now, your first question is, has the client been in touch? Now, if you're making an assumption about the contact that you've had with the client, so say for example, hey John, just getting the finance prepared, we'll have it within the week, you know, that's fine. But if you've made the assumption that yes, they're going to pay, yes, they've got finance, and you haven't checked that, you know, just be a little bit careful. Now, we enter into contracts with procedures so that all parties are aware of what is required of them and when those things are required by. Now, if you have regular site meetings with your clients, you can use these meetings to, keep your client updated as to where the works are up to. You can put them on notice as well. You're doing your final, not a final walkthrough, but just before, the building works are complete, and, you can say, well, we're pretty much at completion. However, we just have to hang that door over there and then we're done. Then, we'll put the lock on and then we'll issue you a progress claim, because that's the final works that need to be done in order for this stage to be complete. So, if you have that communication with them, that's great. What this also does is, puts them on notice so that they can, start sort of looking at their finance. They might notify their bank or their broker to say that we've been to inspect the house, it's almost finished, we'll go from there. Now, the client has been in touch with us, so, put a deadline on it. If they say paid within the week, do we give them the 5 days, do we give them the 7 days? What does your contract say in terms of liquidated damages, in terms of interest and those sorts of things? Where are you up to in terms of your date for practical completion? Now, the next thing is, does the client have any concerns? And if so, what are they? Now, if we sort of have a look at, last progress claims, a majority of them are held up because the client believes that there is an issue. Okay, this could be works not completed, defective works, so on and so forth. So we just need to sort of work out if they do have any concerns. Now, remember, under the building contracts, and this applies to ACT and New South Wales, because that's sort of the region that we deal with, and I know that some of you do build within both jurisdictions, is, we have the right to set off. Now, a lot of people do get confused with that. What it means is the client does have the right to withhold the amount which would be reasonable for the completion of any uncompleted work or defective work. So they might say retain $500 because, there's issues with the plaster on the wall, but they can't withhold the full amount type thing. So, that's just one sort of minor example of, the client's right to set off. Generally speaking, again, if you have that communication with your client, you'll work out what's going on. They'll do their final inspection in accordance with the contract, you'll issue a progress claim, and then they'll come back to you to let you know if there are any issues. Now, the other thing is, does the client have the funds for the final progress claim? Again, you need to refer back to your contract regarding your rights to request evidence of the client's available funds for the project. Now, another sort of good example as to where issues do arise is where, say, you've left a variation to be paid at the end. Now, you might have a contract price of $350,000. You've got a variation for the kitchen which was an extra $20,000. Along the way, did you get evidence of the client's ability to pay for the variation as well? And sometimes that can also hold up, the final progress claim. So if we move on, the client hasn't paid their last progress claim. They've promised that they pay you within the week. We've now gone past that week sort of grace period. Has there been a breach of contract? Well, technically there has been a breach. The client has promised to pay within 5 days. You've then gone on and give them an extra 5 days. So yes, there is a breach of contract. Now, what do you do? And then we also need to look at what are you going to do about it. So, do you have any rights or obligations under the contract? So, what does your contract say? Now, this is vital if you are going to do anything about it. So, under most contracts, it is important to go to, say, Clause 17 of the New South Wales new dwelling contract, which refers to the payment of the progress claims. Now, just a reminder that in both ACT and New South Wales, progress claims can only be issued upon the completion of the stage. Now, it is one of those things where, you know, what constitutes the completion of the stage. So my advice to you, and, you know, if you use the standard HIA progress payment stage or progress payment claim or schedule in the contract, that actually sets out those stages quite clearly. You might do, say, your own custom progress payment schedule, which is completely fine, but just make sure that it's descriptive enough so as to define and be very clear in defining what will constitute the completion of that stage. So then we look at, you know, your contract specific info, and like I said before, clause 17 for the New South Wales new dwelling states that the progress payment claim must be paid within 5 working days of the builder giving the claim. Now, when there has been a substantial breach of the contract, so a failure to pay any amount by the due date under the contract is actually defined as a substantial breach, there's a number of things that you can do. Now, keeping in mind that with sort of a final claim, practical completion claim, you know, there's a different process. We have to go through the handover. The client then needs to identify whether there are any incomplete works, works that haven't been done, or any defective works that prevents them from actually using the property or using the dwelling for what it was intended for. So then we have to sort of also jump through those hoops to make sure that we've dotted our I's and crossed our T's. We're now talking about the next stage where they haven't paid. So what we can do is we can issue a notice of breach. Now, it's always my advice that if you are going to issue any notices under the contract, that you do seek independent legal advice. When there is a notice, again, referring back to your contract, the notice needs to be in writing, and it needs to specify the details of the breach, as well as to say that if the breach has not been remedied within 10 working days, which is in accordance with the contract, that the builder will be entitled to terminate. Now, if we sort of fast forward a little bit, after 10 days, you know, another notice stating that the breach has not been remedied, you know, then we can sort of look to terminating the contract. So what you should also think about doing is suspending the building works. Now, if we sort of look at these, you know, not just in relation to the last progress claim, but any of your progress claims and or variations along the way, you know, you also have the right to suspend the building works. Refer to clause 25, but just remember that if you're going to suspend, again, it needs to be written notice as to why you're suspending, so i.e. for the breach, and then you as the builder need to also recommence the carrying out of the building works within a reasonable time after the owner remedies the breach. Now, unfortunately, I know that, you know, if you do suspend the building works, it does cause a big kink in the chain. You have to sort of then tell your contractors not to turn up to site. I know and I understand that your contractors then go on to other works and they might not be able to slip you back in at short notice. So sometimes this can have an effect, which is why the contract says within a reasonable time for you to recommence. Now, don't forget to also claim your extension of time under clause 19. Again, it's got to be written, it's got to be detailed in terms of the cause of the delay and, you know, what the, I suppose, anticipated extension of time is going to be. Now, in terms of your notices, just keep in mind that the notices generally are done by delivery, which is personal delivery to the other party, posted by ordinary or registered mail, sent by fax, or another method as stated in the contract. Now, we're in the day and age where we use email for a lot of things. So what my recommendation is that you sort of think about putting in a special condition, which also allows notices to be issued by email. You have to be careful though, because in the event where the client issues you a notice, you also need to ensure that you're checking your emails and that you act, quickly upon those notices so that you don't get caught out either. Now, the only thing that I wouldn't recommend notice by email is, say, for a notice of termination. So your special condition might say something to the effect of, the builder and the client agree that email service of any notices but for a notice of termination is acceptable under the contract, and that sort of remedies that situation. So then we sort of look at, what do you want to do about the client not paying this progress claim? So like I said, we've got the options. We can either take the hard line, which is issuing the notice of breach, a suspension of the works, and making the claim for the extension of time. Or if your client's been up front, they're just having a few issues getting the funds from the bank, you might wait the extra few days for payment. This is completely up to you. It's your commercial transaction with them. It's a matter of your relationship and, again, the communication between you and them as to where the parties are up to. So then this comes down to the communication to your client. So step 2 is essentially speaking with your client. Now, we have this wonderful guide available to members. Now, all of these guides are available on the website, and we also have a 3-part series on the topic of improving communication skills, which is a webinar, which is also available. But this guide I found really handy when, assisting members. My, I suppose, favourite line out of this, and I suppose it's one that we can all relate to, is a lot of time and money can be wasted through poor communication between building business owners and operators on the one hand and the clients on the other. Now, we've all heard the horror stories about how much time and money gets sucked up into, disputes with clients. So we want to do what we can to minimise the risk of that happening to you. So some tips to use. As you can see, there are quite a few here, and these are all found in the guide, Communicating Better with Your Clients. So the first one is, don't be afraid to speak up. Now, communication is a two-way street, as you all know. There's no point one person giving a message if the other person doesn't understand it, doesn't listen to it, doesn't do anything with it. Now, active listening. We encourage the use of active listening, and this is pretty much the shorthand for responding to something that somebody has said in a way that lets them know that you're on the same page. When active listening is used properly, it will result in the other person being more willing to negotiate a suitable outcome, because they will be feeling that whatever the solution or outcome that you suggest will address all of their concerns. You'll also find active listening especially valuable for those situations that look as though they could easily end up in dispute. Now, I recently presented this seminar at my IR and legal session here at the ACT office, and one of the examples that I used was, I'm the client, I'm talking to the builder, I have a conversation to say that the door is sticking as it's opening and closing, and I'm not talking about the locking mechanism, I'm just talking about the way that it's been hung. I say that to the builder might just turn around and say, well, okay, I acknowledge that the door is sticking and I'll do something about it. It's just a matter of taking on board what they're saying and letting them know that you listen to them. Now, planning ahead. Like I said before, if you fail to plan, you plan to fail. A building job, and it doesn't matter how big or small it is, consists of a chain of events where one event depends on the other being completed. Any change to this will probably have an impact on your business in terms of time and money, and it will also implicate the time frame specified in the contract. So if you have a plan, and this applies to, you know, the building process, if you're sort of dealing with a tricky client, you're going to be in a much better position than if you didn't have a plan at all. Now, keeping records is also important. Now, it's good business practice. I know a lot of people have site diaries. I know that people have notepads that they keep on each site. They have, you know, file notes that they keep on the client's files. Whatever you do, a simple note in your diary can be enough to jog your memory, and, you know, you can use that as sort of supporting evidence. You know, should the client ever say, we never had that discussion, you can go back to your diary and say, well, on the 1st of March, we spoke about the sticky door, and then they sort of, you've got that evidence there to support you. Now, it doesn't have to be a 3,000-word essay unless it's one of those very sort of nasty situations, but just, you know, a few comments on what has happened, who was there, what was said, and what needs to be done. You know, that's going to be enough for you to use as a record. Non-verbal communication is simply body language. Now, it's handy to know a little bit about body language because it will give you some clues about, first of all, how to deliver a message to the people that you're speaking to in a way that it's likely to be heard and understood, but also you can read their body language as well. The classic examples of the client, you know, tilting their head, not looking towards you, you standing there with your arms crossed as you're talking to them, you know, they're all indicators of non-verbal communication, which might be taken not in a positive way. It might mean that they're disinterested. It might just mean that, you know, your message isn't going to be, you know, communicated effectively. So we just need to think about what our body language is saying to them when we're talking to them. Now, verbal communication, this one can be quite controversial and, you know, I've heard some very funny stories about verbal communication. This gives us a clue to a person's state of mind and, you know, their verbal communication with you may also be reflective of their attitude. If we sort of speak in a monotone sort of pitch, you know, we might be bored, we might not be interested in those sorts of things. If we use a high voice, we're very enthusiastic, that's going to be quite different. If we are abrupt, that's also going to have an impact on, you know, how our communication is coming across to the client. The same thing goes for clients. I've heard of crazy stories where, you know, the clients just turn up to a site meeting and they just yell and scream at the builder. If that happens, you know, my advice is to terminate the meeting, get your client to, you know, come back at another time, or, you know, if you can sort of extinguish the situation, get them to calm down a little bit and then speak to them, you know, you're going to be in a much better position. Now, be aware of different personality types. We all know that not everyone is the same. Sometimes working out how to handle different personality types isn't as easy as you think, and we need to work out how to best deal with the personality type. Now, if we're shy, you know, we might just smile and nod and just accept what, like the client might just smile and nod and accept what you're saying. If they're sort of a person that's a little bit more outgoing, they think that, you know, they're in a better position than you, you know, you also need to be able to adapt to the personality type that you're dealing with. Some people like conflict. Don't give in to that. Some people will just be, you know, the clients that are the most perfect the whole way through, and then they'll get to the end and then, you know, the husband or the wife takes over and says, well, no, during the whole thing you didn't listen to what, you know, the other person had said, and you just have to be aware of your ability to manage, you know, these different personality types. So then if we move on to some traps to avoid, try not to let yourself get distracted. Now, sometimes getting distracted is very easy. It happens to all of us, it happens to me, and it's going to happen to your clients as well. What we try to recommend is that you keep a focus on what you're trying to get through. If you have a focus, it will be less likely that you'll be distracted. Don't interrupt the other person when they're talking, and the same goes for your clients. Don't let them interrupt you while you're talking. As the point suggests, if the other person is talking, do your best to listen and not interrupt. And if you also listen to what they say, again, keeping in mind your active listening and those other, nice tips that I just pointed out to you, it's going to help you prepare your response. In law school we were always told, have somebody say something to you, have a quick think about it and then respond, rather than just being instantly reactive, because sometimes that can implicate your situation. Now, it's really, really easy for me to say this, but try not to let your emotions interfere. Now, I know that you all have a lot of time and money invested in each project that you do. I also know that this is a commercial transaction that you're entering into, and sometimes it is hard to stop your emotions from crossing over into both spheres. Now, it's a big emotional commitment. It's a big financial commitment for your clients as well. When they do enter into a building project, they're trusting you to do what you're going to do under the contract. Instead of being bogged down too much in it, and if you do find that either yourself or your business partner are quite emotional in it, try to get them to think about it from outside the box. If another person that wasn't a direct party to this, how would they see it, and what could be the best ways in moving forward. Feel free to give me a call. I don't have the emotional attachment that you do, and I can sometimes see the differences between and I can see some things that you might not see because your emotions are there, you're dealing with a nasty client, and you just want to get them off your back. Now, moving on, selective hearing is where a party only hears what they want to hear, and this is not beneficial for either party, particularly during a negotiation or where you're trying to get to some sort of resolution. Now, you need to make sure that you're clear with your communication and ensure the parties are on the same page before you both move on. Now, again, I've heard some quite funny stories about where the client has only heard what they want to hear. Yes, we'll change the tiles, but it'll cost you $3,000 for that change because you're getting different tiles. The client just hears, yes, we'll change the tiles for you. They get the variation at the end and they think, well, no, you didn't tell me that at all. Again, going back, if you have your record to say, and particularly your variation in this instance, yes, they've heard what they've wanted to hear, however, you've got them to sign to say that they will pay the additional cost. So then we look at some other common traps to avoid. Now, it's one of those things where you can say no to your client if you don't feel that it's realistic for something to occur under the contract. It can be during the process of the initial contract negotiation, the project planning stage, during the building process, say for example to variations and those sorts of things. You can say no to your client. Now, another good example, and again one that comes across my desk more often than not, and more often than it probably should, is those members that come to me to say, well, I didn't have a good feeling about the client before we signed up and now I'm having issues with them. this is where, your gut feeling, they've done university studies to say that, 9 times out of 10, if you get a bad gut feeling about something, don't go with it. You can say no to your client, including potential clients, if you feel the need that you have to. Again, it's really easy for me to say this, but looking at things from a commercial perspective rather than a personal perspective is going to be one of those things that can help you out of a sticky situation. You're all emotionally and I suppose financially invested in these projects. If you look at it as a business arrangement rather than as a personal hit, then you're going to be in a position where it's going to be clearer towards that outcome. Now, as I mentioned before, clients can use claims of defective work to avoid paying you. So it's essentially a buffer. It's a smoke screen, so that, they try to pull the mickey over you guys, and they say, well, I'm not paying you because the work's defective. Go back and check your contract. The other thing is, if they are getting too tricky, you might have to establish a relationship with, say, an independent builder or a building consultant to come in and have a look at the works that you've done. And then, if need be, they can provide a report to say yes or no, the works are defective. One of my favourite tools, and this is something that I use on a regular basis, is the HIA Guide to Materials and Workmanship, or the Guide to Standards and Tolerances, particularly in relation to defective works, because not only does it give you, the inspection of defects, which, as we all know, is 1.5 metres away in a non-critical light, it also sort of gives some minor, not so detailed information in relation to what I suppose the standards and tolerances are in relation to a range of different works, say in a residential build. I'll touch on that point in the next couple of slides as well, because that is something that we do have available to members on the website. Unfortunately, reality TV shows like The Block, Renovation Rumble and those sorts of things, they have changed, clients' expectations of the building work. This is also something that, does have an impact on your business. Now, for the members that are located in New South Wales Fair Trading do have their building inspectors that can come out to give you a hand with any allegations of defective works. Whether or not you've used them, I generally get feedback from members to say, we've had somebody come out, the client has, alleged that it's defective, they've come back and said that it's not. So it can be one of those useful resources that you have on your side. Now remember, if you have a client who has claimed that there are defective works and you arrange for somebody independent to come in, so whether it be Fair Trading, whether it be another builder who's not your mate that they see you, sitting out the front with, having a couple of beers, if they're independent, it might sort of be that small thing which sort of neutralises this situation, shows that you're confident in your work, you're happy for somebody else to come in and have a look at it, and that you have nothing to hide. Sometimes clients are quite easily satisfied if you respond to their email which lists 50 different defects. If you just come back and say, we don't agree that it's defective and this is why, and you either refer to, say, the HIA Guide to Materials and Workmanship or the Standards and Tolerances, you can come back, refer to page 6 in relation to, corners cracking or something like that. They'll be satisfied with that. Now, if you do require further advice, and this is step number 3, feel free to give me a call. We can provide you with general advice in relation to issues and what you can do to resolve it. In the event where you find yourself in the tribunal, or, worst case, if you do end up in court, you know, whilst we can't represent you, we can put you in touch with people that can. We can try to help, you know, work out what needs to be done so as to help you prepare for those sort of hearings. Now, we do have access to solicitor member lists. Now, irrespective of where you are located, we have ones that are for regional and metro, and all the solicitors on that list are members of HIA, and they do know and understand building and construction law. Now, if you contact me and you say, have a question about defects, now if I can't answer the question, or if I can't point you in the right direction to, say, the HIA Guide to Materials and Workmanship, I'll put you in touch with somebody from our technical team. They're amazing. They know the BCA or the NCC, the Australian standards and all those sorts of things like the back of their hand, so they are able to help you on those things. Alternatively, you can contact a solicitor. If you've got somebody, you know, that looks after you for a number of different reasons, you know, feel free to contact them. But like I said, we do have the HIA solicitor member list available to you. Now, like I said, we've got the technical team. They're a bunch of great people, and you know, they were also very influential in the preparation of the Guide to Materials and Workmanship. This guide is available on the HIA website. We also have, like I said, the solicitor member list. Now, just recapping on the common issues. So, common issues are tricky clients. Another thing that, you know, we do see is where the parties don't actually understand the contract and where they don't administer the contract correctly. Now, this can be from both sides, so both from the client's side and from the builder's side. So, you know, like I said, take me up on the offer, give me a call or send me an email, and, you know, I can make sure that, you know, you understand what your rights and obligations are under the contract, but also how you can explain them to your client too. Now, evidence of finance, again, it's crucial. You need to ensure that the client has the ability to pay you for the works that you're going to do. You can, under your contract, you know, request this at any time, and the client needs to be able to provide you with that within two days. Now, threats of legal can be quite tricky. You know, if you do get a threat of legal action against you, give me a call or contact your solicitor. Don't sit on it for too long. Again, if you do get a legal threat, I suppose if you get any correspondence from a solicitor, you receive any notices under the contract, act on them sooner rather than later. Now, dealing with issues as they arise is also quite important. Don't let them sort of snowball out of control. So now I'd like to open up the floor for any questions that you may have. My contact details are here, and I'm happy for you to write them down, save them in your phones, write down my email address and flick me an email. That's what I'm here for. I'm here for you guys. I can do face-to-face visits. I'm travelling around to regional New South Wales in May, so if you would like to book an appointment with me, I'm happy to meet with you and discuss any questions that you do have if you don't want to talk about them now.
Great, thank you, Christy. If you have a question for Christy, please type it in the question box now and I will start running through them. Christy, you mentioned, I think, during your presentation that if you do end up suspending building works, obviously that has a flow-on effect for the time that it's going to take to finish the job at the end. So is there something that should be done to make sure that there is that extension of time at the end or change in the contract?
Yes, definitely. So making a claim for your extension of time would be crucial at that point. Now, I do receive a lot of feedback to say that people don't make their claims for extensions of time, either for wet weather or if there's a delay during the course of the building works. And I just shake my head and scream a little bit and say, well, you know, irrespective of what it is, always claim your extension of time, because it's better to finish sooner with a longer, you know, building time frame than to sort of get right up on your date and then realise that you've got another week of work to do. And then you've got a client who wants to book removalists to get into the property, and you won't be able to let them in. So always claim your extension of time and check your contract for the actual notice requirements.
Okay, great. Now, another question I have is, in New South Wales, is there a time limit for recovering a debt?
In terms of debt recovery, if you can get onto them sooner rather than later. Now, we do have limitation periods. Now, I don't have the information in front of me, but generally speaking, I think it's about 6 years. Don't quote me on it. Like I said, I don't have the information in front of me, but depending on your jurisdiction, it will be under your Limitations Act.
Okay, great. Are we able to provide a copy of these slides? We had some information about inspections and we'd like to share it with our team. Thank you, great presentation.
Wonderful, yes. I'm happy to forward out a copy of the slides. In terms of some checklists and those further information, if you'd like to contact me direct, I'm happy to run through some processes which might be specific for you.
Okay, great. Now, I think one of the things you touched on a few times was the idea that if there is, I guess, a sense that there is going to be an issue, or if they do start to get some feedback from customers that perhaps they're not going to make a payment, the first thing they should do would be to contact you. Is that right? Rather than, I guess, trying to deal with it on their own, best to get some advice from you?
That's correct.
That way we can perhaps nip it in the bud. So do you...
Yes, the sooner we...
Sorry.
The sooner we get onto these things, the better it is. And, you know, even if it's sort of one of those things where you think you know the answer but you're just not 100% sure, just give me a call or send me an email and I can point you in the right direction.
Okay, and also you mentioned, I guess, I know that we often get calls from members who are having difficulty with their customers when it comes to variations to the contracts, and perhaps if you could just touch on that again, if a client is requesting a variation, just how they need to document that and have that proof so that when it does come time to pay that, you know, everybody has agreed that this is the amount it's going to be and this is how much you need to pay, and there can't be, you know, hopefully you're minimising any disputes.
Yes, sure. So if we refer to clause 18 of the contract, and this is the New South Wales New Dwellings contract, it simply states that a variation must be in writing and signed by or on behalf of the builder and the owner. Now, when it comes down to variations, variations can be requested by either the builder or by the owner. And a reply to a variation, like I said, needs to be written and signed. It needs to specify the work to be carried out as a result of the variation, the price of the variation, and any extension of time to the building time frame which results from the works being done under the variation. Now, in the event where the owner doesn't give the builder signed written acceptance of a builder's offer within a certain time frame, and under this contract here it's 5 working days, the builder is then, his offer is then deemed to be withdrawn. Now, if you don't agree to a variation, then that's fine. If you, say, have a client that doesn't agree to a variation that you're proposing as the builder, which you're required to do to sort of comply with your regulatory sort of requirements, or your local council has come to you and said, well, we need to change X, Y, and Z for these works to be compliant, they can't unreasonably withhold their consent to that variation. Now, the most, I suppose, the common thing is, make sure it's written and signed. The other thing is the price of the variation is due and payable at the next progress payment claim, unless it's agreed otherwise. So, for some people, they might say the variation is due and payable in accordance with the next progress claim, which is fine, which is what's specified under the contract. Some people might say, well, okay, for whatever reason, we'll do it right towards the end. But in saying that, always ensure that your client does have, the available funds for that variation, as well as the other costs under the building contract.
Okay, great. We have another question. It's the last one I have, so if anybody thinks of anything else, just quickly type it in. With an ACT contract, if a client is late with a payment, there is not an automatic time extension unless the builder suspends the work in writing. Is that correct? And Matthew's quoted clause, I think 12.5B.
Okay, bear with me for just 1 second. I'm just opening up my contract. Okay, so is this under the new dwellings contract?
Matthew, if you can just type that in, we can. I love it. Yes, it is.
Okay, so just double check that you are using the most up-to-date version of the contract. But if having a look at 12, like clause number 12.
So what version are you working on? What's the up-to-date one?
Okay, so this version is July 2013.
Okay. Matthew said he's looking at the latest online one.
Okay, wonderful. Okay, so 12.5B, to suspend the building works in accordance with the suspension of building works under clause 24. So clause 24 sets out the requirements for the notice. So again, it's got to be in writing, and it sort of needs to specify what the breach is, and that in the event where the owner corrects within 5 days of the notice, the building works must then recommence within a reasonable time frame. Just going back to Matthew's question though, if in the event where they don't make the progress payment after it becomes due, then first of all you can charge your interest, and you should all be charging interest under your contract, and then suspending the works.
But there's not an automatic time extension, is that right?
No, there's not. No, there's not. So you will have to make your claim for the extension of time separately.
Okay, so Matthew said thanks for that. So that was the last question we had, and we are right on the hour, so that's always good. But I really want to thank you, Christy, for your first webinar. Hopefully it wasn't too painful. And for my New South Wales members or the ACT members who have joined the webinar for an hour, and if you do need a CPD point, I've just if you could put down your details in the survey at the end, I can organise a point for you for attending live. I'll have this recording up on the website shortly, as I said, and for people who have attended live, we will. I'll send through the slides as well. So thanks again, Christy, and Beth says thank you as well. Thank you everybody for joining us, and we have another webinar next Wednesday. Actually, I shouldn't promote that one because that one is now full, but I'm hoping Christy will be doing more for us for ACT Southern New South Wales members over the next couple of weeks and months as well, so please keep your eye out for those. So thank you, Christy. Thank you everybody for joining. Thanks, Tony. Bye.
Thanks, bye.